Every day in the USA, people find themselves in court.
I think we're unmuted. Okay.
All right, good afternoon. My name's Dave Nelson. I'm the Judge Pro Tem that will be hearing the small claims matter today. I think I need to disclose this. Several years ago, probably going on 10 years ago, I was a commissioner in the Superior Court involved in a matter with Mr. Salim. And I wanted to disclose that. I think I'm required to, and if that causes either party any concerns, then we can reschedule this hearing for another day. Mr. Salim, do you have any concerns with me hearing this case?
No, Your Honor.
Okay, thank you. Please tell me how to pronounce your last name.
Yeah, it's Amjad Al-Shakarji and Audrey Menezes.
Menezes? Okay.
Yeah.
Do you have any concerns with me hearing this case?
No, Your Honor.
No, Your Honor.
Okay, thank you. All right, so this is a small claims hearing. Both of you have submitted materials. I'm going to go through those in a moment with each of you. And then Mr. Salim initiated this case, so I'm going to swear him in and hear from him first. And then I'll go to the defendants and counterclaim plaintiffs, and I'll swear you in and hear from you. And then Mr. Salim will have a chance to respond. And since you brought a counterclaim, I'll give you a chance to respond to whatever he says. In reality, I'll let you both tell me your side of the case until we have all the information out. Okay?
Understood.
All right. There was a lot of documents submitted, I believe, by the defendants, right? This is the notebook you submitted.
That's correct, yes.
All right. Mr. Salim, did you have a chance to review that notebook?
I did, Your Honor.
Okay.
Most of it is a lot. Yeah.
Is there any parts of it that you object to me considering?
Your Honor, most of the file is copies of emails and instructions for the couple and just planning through the time they were with us. There's nothing, there's so much in there, but majority of his conversations that we had gone
Okay.
back and forth, and
the rules of evidence are relaxed, if not non-existent, in small claims hearings. So at this point, I'm going to admit all of the documents that the defendants have submitted. I also have a package of documents from Mr. Salim. They're labeled A, and let me go through here. I see A, B, C, D. Looks like we're up to S. And did you have a chance to review that, Mr. Al-Shakarji?
Yes, we had the chance to review that.
Do you have any objection to any of those documents being considered?
No, we do not have any objection.
All right. So at this point, the court will admit all of the documents that have been offered in this case. Thank you for cooperating with that. All right, Mr. Salim, I'm going to place you under oath and then ask you some questions. Do you swear or affirm to tell the truth in these proceedings?
I do.
All right. Sir, I'm just will open it up and let you tell me why you brought this claim and why you're asking for the amount that you're asking for, and maybe tell us a little bit about the relationship between the Empress and these defendants.
I have sent a cover letter. I hope you have got it, Your Honor. That explains all of timelines and things that I have had. The reason is the couple came in to book with us, like any other couple, and have signed a contract that has clause in it, and also we were given kind of a proposal to what our foods and things like that. The defendant electronically signed the contract on April 13, and then made 5 payments every month while we're talking back and forth through the emails that we attached, and so as they did. And then they had 100 people on that proposal, Exhibit A, Your Honor. You see the contract, and I've highlighted most of the important stuff, especially cancellation policy. And then
I see that in that's the first document I believe they submitted, and maybe it's identical to your A. Let me see here. It is. So the cancellation policy is number 7. Is that right?
That's correct. Yes.
All right. And it says if the client cancels the event, all retainers paid up to the point of cancellation will be forfeited as liquidated damages with no exceptions. The Empress Estate recommends purchasing wedding cancellation insurance to protect against unforeseen circumstances. So this cancellation was, I understand, 10 months before the date of the wedding. Is that right?
It was the cancellation was on 10/1 of 2025.
And the wedding was going to be in June of 26, right?
That's correct. Yeah, we book more than a year in advance to 2 years in advance, Your Honor. That date has not ever been booked so far.
So is that part of what you claim as damages, is that you've set aside that date and you're not able to fill it even 10 months out?
Exactly. They held the date for the 5 months that they were there, or 6 months, and then just decided they wanted different things that we don't allow, and we try to accommodate them as much as possible, and then they decide to cancel. And we always have repeatedly asked them to buy an insurance, which is around $200, would have resolved all this issue completely. They also have that in their Exhibit B3-1, which is in their file, that exactly shows the cancellation. It's also in the contract recommending that. So the insurance company can pay them whatever they have. We tried to do that also when they canceled. We been trying to instruct them, please contact your insurance. However, they never bought that, several times, actually more than.
This relationship fell apart because of the costs you wanted to charge relating to them bringing in an outside caterer, right? And
that's correct.
Your policy is you don't use outside caterers, right?
That's correct, Your Honor. And the contract.
So I've got an email, it looks like from you. It says caterer collaboration. We are excited to work with Adat Cuisine of India to provide the entrees and appetizers for your event. And then it talks about when the buffet will be set up and food preparation. It says a dot will prepare all food off-site in advance. They will deliver it to the venue where our kitchen will be available for warming and any final touches. That doesn't sound like a no to me. It sounds like you're very cooperative in working with this particular caterer.
Uh, Working with the couples, Your Honor, we try to do our very best, even though there is a clause in our contract that says banquet order number 5, and it says that outside food and drinks are not permitted unless approved by the Empress. Okay, that's in the contract, but we do our very best since there's a cultural dishes and things like that. However, they raised their amount of people from 100 to 200. When they came in, when they signed the contract, they were taking our food, our things. They have a proposal for 100 people, the Empress package, and an Exhibit A, and it has the price and has the payments and everything, just like the rest of people. But then they insisted on that they wanted to have their own foods. We tried to accommodate that at the risk of our, licensing and stuff like that. But we go the extra mile to trying to accommodate people. And this was 5 months after they have already assigned anything. There was no initial conversation about this, Kiri. But we try our very best. If we can make it happen to accommodate them and the new culture, we try that. It's just we're in the service business,
Their concern
for that.
Their concern was the extra cost of using their own caterer, and it looks like from the email I just read from, there really is no reference to there being or what the cost might be for using your own caterer.
You're right, Your Honor. We don't allow outside caterer at all. We have never allowed that. This is one exception that we tried to work with them. It says on the contract we don't allow outside caterer because of our services. However, we accommodate them and we try to do that. But we try to get them down to $3 an item to just make it. We cannot serve them for free. And so the minute they raise their amount of people to 200, the price went up, and I only I went down to $3 a plate to service that for them. Very little amount to really accommodate, go the extra mile for my clients. And that's what I did.
So your costs were to take the outside caterer's food and whatever it costs you to plate it and provide it.
Well, staffing and
was the
kitchen,
$3.
Chefs, and it's all. We're not a venue that a caterer just comes in and does his thing. We have actually waiters and busters and bartenders and kitchen staff and dishwashers and all that. And then $3. We try to really accommodate them at the very best we can to make this work.
Okay.
But neither before them or after them have I ever authorized that. But I just had a thing that I'm trying to work with them as much as I possibly can.
Just a moment here. I want to pull up something. So your claim is for $4,868.64. Can you tell me where that number comes from?
So, Your Honor, they had 5 invoices. Each invoice was $1,217.60. They have charged back that. The first step, the credit card company actually gave it back to us, but then it went to arbitration, and that's when they have a different cause of chase. And so I have put in 4 different invoices in there, and then the other or four different invoices, then I wanted to file again in another case to do one more and the arbitration cost, which is $1,800. So that's how I plan to do that. If you would allow me, I would appreciate that very much, that we have to go through this whole thing again because of the limitation of the court. But I gave also in that letter a second option. If Your Honor not going to agree to that, then I go to the minimum of $5,000, and the arbitration is another clause on my contract. This whole case is similar to a lawyer case. You put a retainer, and the lawyer gives you a date, and you go on, and then you can't just ask the lawyer to come back and say, "Hey, give me my retainer back because I don't like this or that," or This is very, very similar to that case that you're familiar with and the court is familiar with.
So were you, when they made the claim through Visa and apparently they prevailed, did that money come from you that they got reimbursed from Visa?
That's correct. Yes.
Okay.
So the first step is the actually processing company. The processing company looked at the contracts and all the invoices and everything, and then decide, okay, we're going to give you the money back because you have contract and signing and all that. Well, the step after that is them filing arbitration with actually Chase, which is another whole game. And with that, Chase has its own regulations where it's just different, and so they did that, and then cost me also another additional $1,800 of arbitration.
So that's included in your claim today.
Well, the $4,800 and some dollars, that's only the four. And I have also written in that email, in the cover letter, that I would like to do another small court to recover the rest of the money. They're individual invoices, Your Honor, and so each one of them was arbitrated in a different time.
Mr. Salim, this may be a legal question, but you may have a thought on it. If this was arbitrated through Visa and Visa determined to refund their payments, does this court have authority to reverse that decision in this case?
Yes, Your Honor, because Visa takes, I mean, I was actually recommended in the very beginning, before Visa, before the Chase, to not go through the arbitration because it's always refunded to the customer. Because how Visa goes about it is, if they work with purchases, for example, if you buy something and then you don't receive that particular item, then they refund you the money. That's how it is. They're not understanding, they don't work with retainers, such as you and I mean, you will probably the best to understand that retainer thing. If for example, you're doing a service to a client, and that client decides, "Hey, I don't like you, I want to charge back," they'll give it to him. However, you will have to go into court and get it from that clients. That's how they work it out. They are specifically work in particular regulations where they're favorable to their card holder. And if you can prove that they didn't get an particular item, buy something from Amazon and you didn't get it, then they'll give you money back. I have to prove that they have gotten this thing. Well, this is totally a different case. So it's not because they have. And Your Honor, I mean, I need to go back to the contract, which is clearly, specifically says that they signed, they accepted a proposal that we have, which is in Exhibit A, that when they sat down with us and we did a proposal for them for 100 people, they chose a package, they chose the foods, they chose, you know, the packages that we have, and we were set with that. This whole entire complication came in 5 months later, and I believe that because the cost was, because they had gone from 100 people to 200 people, they thought, well, they need to go and get a caterer from outside that's cheaper. We try to accommodate that all with all goodwill, to trying to, even at our detriment of having somebody else come to our kitchen. A restaurant doesn't allow somebody to bring their food into their restaurants, but we did. We tried. We thought we can work it out with our staffing, and there's, you know, all that kind of stuff, Your Honor. But to go back to the contract, this specifically has in several locations that retainer will not be refunded. You're holding a date. We book way in advance, and then also the deposits. I mean, the retainers is just not refundable, and we don't allow catering from outside. This is the only couple that I tried to work with and give a goodwill gesture to trying to work it out, and I dropped it down from $10 per plate, okay, per dish, to $3, just to make sure, you know, and you can work it out with them, which was the same cost as actually their proposal. So I really tried very much everything I possibly could. They could have resolved all this, completely resolved it. We would not be here. We would not be in arbitration in any way if they had spent $200 to get insurance, which have been told to them in the contract, in email, in documents that we provide to the bride and groom as documents information, which they have that in their exhibits. And if you look at the exhibit that they have, B-3-1, you'll find exactly an explanation to please do that. And they decided not to do that for $200, and we have to go through all this time and effort and waste of money and arbitrations. And that's why we try to stay away from that, telling people, please buy that, not just to protect you from a venue, but also your DJ could get sick, your wedding planner could get sick, your whoever, you know. It really does help that, but they haven't. And we, even in the cancellation email, I asked them to go ahead and get that insurance so we can resolve that. And they just decided, no, you have got to give us our money back. And that's where we are now, unfortunately.
All right. Thank you. I appreciate your testimony.
Thank you.
All right, let's turn to the defendants and the counterclaim plaintiffs. Who wants to testify first?
I can testify.
Okay. Raise your right hand. Do you swear or affirm to tell the truth in these proceedings?
Yes, I swear and affirm to tell the truth in these proceedings.
Okay.
Um,
Go ahead.
Before moving forward with this venue, and during our initial tour, this occurred on April 13th, 2025. So that's the date that we signed our contract and spoke about it. We explicitly communicated with both Zoe Salim from the Empress Estate, as well as Kim Rodney, who was the wedding coordinator at the venue, that we were looking for a venue that would allow us to do outside catering. Because we were looking for a specific venue that would allow the outside catering in a buffet style that provided halal food for our dietary and religious restrictions, and also to be able to have it like fit the traditional needs of the wedding that we want to do. During that discussion, we had that conversation with Zoe, Salim, and Kim. We were all there, myself and my fiance, Audrey. We were all there together talking about this, and we went through it in detail. Like, we spent at least an hour going back and forth. So Salim was there with us when we talked about this. So to state that we never talked about this before and that this was the first time this has come up, we believe is false, because that conversation happened and multiple people were there, and we wouldn't have gone down the path of searching for an outside caterer if we had never discussed it or never even contemplated the topic of having an outside caterer.
What was Mr. Salim's reaction to discussing an outside caterer?
Initially, he mentioned that they typically don't allow outside catering during that time period, but he's willing to make an exception, or he said that maybe we can contact or talk with the cook and have them come and like work out with their cook. And they can supplement some things in their menu. So at the time that we discussed, they said that we had to meet the minimum payment requirements, which are spelled out in the contract itself, where it says that you have to meet the 4,900 minimum that's there. And at that time, even after we expressed, there was no mention of any additional fees. The only thing that was mentioned was that we would need to meet the purchase minimum that was required by the venue.
Okay, go on.
And from there, we went, and when we were during the signing process with Kim Rodney, like, we had the choice that selected for the Empress Choice package, and we asked again during the signing that about outside catering and where this would be in the contract, and they just mentioned that, at least Kim mentioned during that time frame, that all we would need to do is we can switch to a smaller package later down the line, and then that would associate with it as long as we still met the catering minimums that were required. So from there, several months go by. We didn't have any official planning sessions that were performed. And per their email that they have with the Empress Estate, one of the emails that they provided, which was email E5, they state that please provide your wedding insurance certificate within 30 days from today, and then this is required before we can proceed with the planning sessions. So to state that there were any planning and there was an active planning session, that wasn't the case, because we hadn't had any official conversations about any planning. We were still in the process of searching for a venue, searching like venue outside options like our DJ, our florist, and our caterer that we were looking at, that we discussed that we want to work with. And that information, that process takes time, because you have to search different caterers, you have to find different options that are there, and to be able to purchase wedding insurance that covers certain things, you have to understand what those costs are and what you need to cover. So for us, we hadn't purchased the wedding insurance yet, because we were still looking at what all the costs are going to be, what each of those individual items are. And to be able to purchase wedding insurance last minute for cancellation purposes is insurance fraud, and that's not allowed.
What, from the beginning, what was it you were expecting the Empress to provide to you?
From the beginning, what we were expecting was that they would allow us to have their outside caterer, that we would choose one of their catering options, which was like the to meet their minimum, and that we would be allowed to coordinate with our outside caterer to supplement the additional catering that was there without additional charges that were in place. And in the exhibits, you'll see that we provided under Section A. So Section A1, that was the original contract that they provided, which is the same one that Salim presented as well in his. And then A2 was the original contract, which mentioned the Empress Choice package, which we initially selected, knowing that or expecting that we would be able to change that package later down the line once we determined our outside caterer option that we were provided.
Okay, let's go through this.
Yes. That's good.
So there's a rental package. It looks like the 4,900. And it looks like you're going to stay in the Empress Suite, so that's another 2,000.
That's correct.
And then the Empress Choice package is 6,900.
That's correct.
And I'm looking at the second page and it says subtotal 19,673. Did you eventually agree to that?
And that was just the initial based off of the guest count that we had in mind at that time.
And that was based on 100 people.
Based off 100 people. That is correct.
Okay.
Yeah, so that was based off the 100 people, the staffing charges, and the gratuity and the sales tax that they had on those catering charges. And initially during that time period, we were looking at maybe going with the Empress Suite that they had available. And then we told them as well that during that time period, we'll need to see like if it accommodates our needs and everything that we're looking for, if it fits the size and if it will accommodate like our grandparents as well, which we later found down the line that they said they don't have any rooms on the base floor level, so it wouldn't accommodate like our the elderly that we had within our group.
What invoice did you get that caused you to want to cancel your reservation?
So if you go to A3, that was the first update. That's after we had a conversation. So at the time, we were asking some questions over email. And from those questions, we were told that we need to have a conversation with Zoe over a phone call. So that was the first time that we had the call. That was on September 19th. And we had a phone call in the evening where that's the first time he brought up the external additional fees that would be there. So in A3, you can see after we had our conversation and we provided the email of the catering information that he asked to get updated details on. We sent him that information. You can see in here that he was charging $5 for each outside catering item, and this is not including the cost of the outside catering itself. This is just additional fees just for bringing in each one of these items. So in total, just for those items from the outside catering that we were looking at getting, it was a total of $8,800.
Was that the pan puri chicken Manchurian?
That's correct. Yes.
Is that what I'm looking at?
Yeah, the fish pakora, tandoori chicken, butter chicken, goat biryani,
and is the rice salad and raita, is that what he's providing?
No, this is still all the stuff from our outside catering as like things that were coming in.
So that came down to $3 a person.
That was $3 per person per item, and then for some of them, and then $5 per person per item.
Okay, this is based on 200 people now also.
That's correct, yes.
Okay.
And the concern wasn't specifically about the 200 people. And you can see even when we switched down to the Topaz package during this, we are still meeting the minimum required for the venue. So we're still purchasing catering from the venue. And we didn't have an issue with purchasing catering from the venue. What we had issues with was all these additional charges that were being put in place, because we feel like if we're already buying catering from them and we're meeting their catering minimums, that it's and if they're saying that they're willing to accommodate, it seems like the way they're setting it up is not to accommodate at all and to force somebody not to be able to do this at all. So and these are all additional fees. This is $8,800, but there's also added fees on top of this. So like these aren't specifically for their crew. later in this package, you'll see towards the bottom, they're also charging the staff charges of 20%, the staff gratuity of 5%, and the sales tax of 7.7%, which is an added 32.7% on top of that 8,800 just for the outside catering. So that leads to a total of 11,677.6 just for being able to bring food from an outside caterer.
Okay. Okay, you got this in, when's the date you got number 3?
That was on the September 20th. So we got an email.
Okay, so we've gone from April to September, and then September you get this invoice, and that's what made you decide to not use this venue.
Yes. So that this was the first thing that we expressed after we saw this. We said, hey, like this is well outside, like the costs, like these weren't originally disclosed, and in our email that we provided to them, which was an email or E25. After we reviewed that banquet event order that was submitted, we expressed our concern, and we said that had we been made aware of these extra charges at the time, we originally expressed desire to use outside catering, and based off of our understanding, then we would have gone with a different venue or gone with a different path, and we hadn't started any planning sessions. This was still several months out from the date that we were looking to cancel. So this was a major factor that played in us wanting to move away from it. From there, the following email, E26, Zoe responds with another banquet event order update and says that this is their best compromise, and that's the next item, that's A4. And in here, he made some price reductions on those external items, but it was still, even with all the added costs, was still more than the value of the outside catering itself, on top of also requiring their outside catering to meet the minimum requirements.
Yeah.
And in A5, that's our conversation, when we were finalizing costs with outside caterer, just getting details in terms of what the totals would be for those items. And with that, they're saying that this is the total that they would go with, plus $1,000 for services for driving out to the Empress Estate, and they would provide one of their main chefs as well as an assistant. So even with that, and we mentioned that to Zoe in our email after we brought it up, that ADOT would be providing individuals that would be supporting with this event, that would be handling their buffet, that understand their equipment, and the caterer was also going to bring their buffet trays, which we described to them during our initial visit too, that we wanted this vendor because they had these nice buffet trays, and then we'd be able to lay that out.
Let's go back to the agreement, the contract you signed.
Yep.
You agree the cancellation policy says what the cancellation policy says?
Yes.
Okay. What's your response to that contract provision?
I know one of the things that was mentioned in the document that Zoe provided, as well as what some of the emails that were provided as well, saying that the payments that were made were voluntary. And with those voluntary payments that were made, at least our understanding that only the initial payment that was needed was needed to reserve the date. So none of the other payments that were made were required for reserving the date or anything else like that. So later down the line, throughout the email discussion with the Empress Estate, it went from sounding like it was something that was going to be voluntary to something that was enforced or necessary or required to pay those additional payments for that. And on top of that, given the initial information that was shared with us and what we had understood and we discussed with them in detail, we feel that from sharing that this is what we were wanting to do, that at that point they were changing what their contract was, or changing things like from their contract, that, if they were working with us and stuff like that, that they should have been willing to accommodate.
So I'm looking at, I guess, Exhibit 2. It's got first deposit, deposit 2, and then third, fourth, fifth. What did you understand was the total needed to reserve the venue?
Well, yeah, so according to their planning document B2, they state that the first payment is the initial payment that secures your event date. So it's the initial payment, the initial deposit that secures the event date. I know Zosalim said that we had 5 payments that we made a total of 6. The first one was the initial payment to reserve and secure the event date, and the remainder were additional payments that were made each month.
I see here on looks like B2, due date of payments. Payments are due monthly on the same day as your wedding day. And it indicates the initial payment secures the event date, but it sounds like they expected deposits leading up to the wedding. So the costs are divided by the number of months remaining until 30 days before the event, with a maximum of 10 payments. So those were going to be required for them to remain an option to you.
Yeah.
Okay.
And
Tell
then-
me what happened with the visa hearings.
So in terms of what happened with the visa hearings, we issued 5 visa claims. 4 claims were from my visa, and then 1 claim was from Audrey's. The 6th payment that was made was done through debit, so it wasn't something that was brought up through visa. We sent in our evidence, which included documentation from here, like the initial contract and so on. And 4 out of the 5 of those were awarded to us. So only 4, which is that total amount that Salim shows, which is at 4,868.64, which is what was returned to us. And then the last one that was under Audrey was not returned.
Your counterclaim is for $7,261.80.
That is correct.
Tell me about that.
Yeah, so the 7,261.80 is the total amount that we paid for all the invoices. In the description of the amount owed, we do say that the credit card claims were filed, and this is how much we received back. So we want to state the full amount that was owed.
But there would be a credit of the credit card claims that came back to you.
That's correct. Yeah. So the credit card claims that came back to us, and it would just be whatever's remaining from that would be the total amount.
So let me ask you this. The Empress reserved a date, and they said they haven't been able to re-rent that particular date. There were a number of emails going back and forth. There was a meeting with them initially. There was discussions about what kind of food you wanted and how many people were going to be at the wedding. They did a tour with you. Do you think any of that should be compensated to them?
The initial tour that we did is something that is, again, something that doesn't require any contract to do there. So the initial tour itself is just like anybody else visiting the venue. Somebody can come and ask standard questions. The majority of the questions over email that we sent are, again, things that were part of normal questions that someone would ask, like understanding what their DJ restrictions are, what type of food items they offer. Like those are typical things that anybody would be able to get or be able to ask outside of being in a contract with the Empress Estate. The only time that we started getting into details more specifically about the actual venue itself was when we started getting into details on the outside catering, which was in September. All the other emails that we had were, again, just reminders, hey, here's a payment, need to make this payment, or something along the line of, hey, like, would you guys have any like recommendations for this? Like you guys mentioned somebody during the initial visit that we had that does like DEPK, or we were asking like if they allow animals, for example, on their premises. So there wasn't anything I would say that is officially planning related that's there, but again, I'm not going to say that that there wasn't any specific compensation or effort put in, of course, to respond to the emails and like putting together some of these things. But like just like anybody that is asking for like a proposal from a company, those individuals are going to come out and they're going to provide a proposal for something, and knowing that they won't necessarily get any business for it. It's just like providing a quote or providing information to try to entice individuals to be interested in choosing that venue. Now, if the event itself, since there was no official planning meeting that we had with the Empress Estate, and they also state that the planning meeting, it can only be conducted, and we hadn't had that planning meeting, we hadn't scheduled it with them, can only be conducted once the wedding insurance is provided, then the way I see it is that we never actually had the planning meeting that they described that we would have that goes over the details, because that planning meeting is intended to talk about our different vendors, how we're going to coordinate, like, where people are going to be placed. So there wasn't any official planning. It was just questions and for us to try to get the details that we needed to prepare for the planning meeting. And Zoe also mentioned and talked about insurance as well for the venue. One of the insurances that like you usually get is tied to liability insurance, which is just to cover the venue itself in case somebody gets injured. And then the other is intended for like if you want to refund something like for like a vendor canceling and so on. So from our like look into insurance as well, and when we started diving into it, I know that Zoe mentioned it's something that's close to $200, $300. It's not something, again, that's also that small of a price for insurance. Like $200, $300 is typical for like a standard just liability, but for any recovery of like retainers, and it has to meet very specific requirements by insurance to be able to make that qualify as well. So even with insurance, even if we had purchase insurance that would have costed well over 200, there's no guarantee even from their clauses that they would even refund any retainer payments. So to force people to say that the only way they can get retainer payments back is if they got insurance, there's even the insurance itself that won't guarantee that you would get your retainers back. And then another aspect too of things that started making us more concerned, especially as we started going through this process and we were going into the process of like going through this challenge that we were running into with the getting outside catering and having that conversation. We started getting concerned about one, the trust of the staff, and also like started observing these different issues and concerns about quality and how we were going to be treated and how our guests were going to be treated at the venue. And we started looking at reviews as well, from different people that had booked the venue or had gone through in detail as that concern started rising. And, which I would say we included a lot as well in our package to.
Those reviews were available prior to you entering into this agreement.
Yes,
Is that right?
that's correct.
Okay.
Yeah.
I still need to, the cancellation policy on its face is pretty clear that if you cancel, you forfeit any deposits that you made. There's a schedule for deposits, and you guys were paying those. So how do I, what's the theory that I disregard that particular part of the contract and come up with another decision?
For us, like, at least for the way that we view it, or that we were seeing it, is that, we had some agreement that we were making with the Empress Estate, and we were proceeding with that understanding and that agreement. And to say that somebody's willing to work with something, or if there was something that they were willing to work with, we wouldn't have expected it to be that astronomical, or to be something that is set up in a way that is to completely discourage somebody, for somebody to say that they're willing to accommodate something and then organize it in a way where there's no way that you would even consider doing that. That to us is like where we feel like, it violates what we originally discussed and what we originally understood from that contract.
All right, I appreciate your testimony. I'm going to go back to Mr. Salim. You've heard the plaintiff's discussion. Any response from you to that?
Yes, Your Honor. I'll go back to the contract, which you see the clause there that are very clear, ambiguous. But to clear things up, we had no issues. If you look at my exhibits, P as in Papa, that's an email exactly the same day that they have signed the contract, and it says, please do this and please do that. It has a planning document link that has all the information about anything the Empress Estate has. Everything from colors to questions to PDFs. So to go back to that, from the April 12th to September 15th, there's no issues. They had a proposal exactly for the 100 people. This is the package. This is the whole thing. No questions about that for 5 months. And then they come back and say, okay, now we want to use this. Now, if they had taken that proposal for 100 people at $19,000 and they added another 100 people, it would almost double. Okay, it would be the same price as I quoted them at that time. So somehow when they doubled the 200 people and then decide, okay, no, we want to do catering from outside, and we try to accommodate in all aspects. We do that with all cultures, Your Honor, because they like some food. We try to kind of work it out, but we do the services, we do everything to control the item. This gentleman, he said,
how much more work was it for your staff when they were already providing some catering in-house? Because
Your Honor, we are
bought
full service.
the Topaz package, which was going to be some catering, and their expectation was this caterer is going to come. They've got their own employees. They're going to put out the food. There's really, their expectation is there's really no additional work for your people. Maybe there's the use of some tables, some plates, that's a dishwasher, but that doesn't add up to $8,000.
Well, Your Honor, we do service per person. We set up, we tear down our tables, our napkins, our things, our services, but we are an
You were going to
establishment
do that
to
anyway.
make money.
You were going to do that anyway.
Going from 100 people to 200 people is a double tables, double the. But Your
I
Honor,
accept
we're not
that,
open.
but it
We're not
looked
open
like
to
you were
just give it away.
charging
Mhm.
$5 per plate. No, $5 per item that this outside caterer was bringing. What justifies that charge when you're already doing some catering in-house?
Because, Your Honor, it's our establishment is a business to make money. This is what capital. We have gone to $3. A usual the topaz you'll see $39. That's the minimum. Okay, we do have the minimum, which is one plate and one compliment. Okay, this is the price for that. We had dropped that to $3. That's a huge. I've got to somehow using the services to do that. We have nothing of this has been risen at all until September. If we had the choice in the summertime where people book most of their weddings, that we had a chance, they would have known that we would not allow this. We did accommodate this. Okay, but on the 14th of April, we had told them exactly the planning document. It's in the contract. We don't allow outside catering. However, we got put into a situation where, if we don't do that, we're going to count. And we tried to work it out for them. It's a really goodwill from us to work it out and make it happen. But $3 to service something McDonald's is now at $20, Your Honor, drive-through. So this is a very minimum. Okay. To go back to the issue, not for the little details that we're talking about, the contract is very clear, regardless of how we conducted going back and forth. He's saying that he misunderstood, whatever that is, but this misunderstanding could have come up before September. Okay. When we get into September, and we go through this, now that he wanted to change and go to outside caterer, he's not accepting the very minimum cost that we're trying to accommodate. A restaurant wouldn't allow you to come in and just use their kitchen because they have no staff. It's the same thing, Your Honor. You get some retainer from someone. Okay, you did some work here and there, and you reserve the date for them. Would you say, okay, no, well, he doesn't like my work, let me give him the retainer back? That doesn't work in that way. We have given him all the planning documented. Everything is in writing. The contract is very clear, very clear. We don't allow outside caterer, even though we accommodated them. That doesn't negate the contract. It says exactly, absolutely, with no exception, that we would allow a return of retainer. So this is kind of where I'm standing and saying, okay, well, here's what I think that's my right to get this money back. Your Honor, you're talking about a date that would have been at $25,000 to $30,000. Okay, that I'm actually negotiating right now at $5,000. So, when somebody cancels, we're not just losing the retainer. We're only taking the monthly from them exactly with the minimum amount. So we have 50 people coming in. We only put the payments for the minimum in case they do drop down to 50 people or 100 people, or 25, or go up. So we just kind of work it out however they changes through the whole entire time. We don't just say, okay, you got to pay me whatever you have, you can't change. So we try to work that out with them, but the contract is clear and it's written, and and I hope, Your Honors, that you see that I have done my best to accommodate them.
All right. So let me
That
just be
loss-
clear. The 4868, that is around $3,068 plus the $1,800 arbitration
No, Your Honor.
fee.
That's not correct. In the email or the letter I sent to you, this is only because the court does not allow 5,000 of invoices.
I understand that, but I'm wondering where the 4868 comes from. Is the
It's
1,800?
four invoices. Yeah, you multiply the $1,217
Times 4.
by 4. That comes to that.
All right.
And then we have another invoice plus the arbitration, which is I'd like to file another small court to get that, which is very small part of what I actually have lost.
All right. Back to the defendants. I'll give you about 2 or 3 minutes additional if you'd like.
I know that Zosali mentioned that business is there to make money, but that also goes to show on the character of the venue that a venue that does something for weddings for couples is there. One, yes, of course, to make money. It's a business there, but it's also to be able to have satisfactory customer service and to be able to work with a couple that's there. And even from the reviews that were in place, a lot of those, showed that, we weren't the only ones that went through something where there was either things that they had issues with staffing or issues with quality of the venue. And that went to show that, we were potentially not even going to have a successful wedding, or things would have turned out differently than what we'd have expected. There's even in a lot of the reviews that people had and that they mentioned, there's also issues with how they were being treated, how the guests were being treated, with staffing issues from the Empress Estate stating that either they didn't have staff that was there, or things that got delayed, or different things. And whatever the reasonings were for those, people, a lot of couples have expressed challenges with those. Now, in the topic of the payments, that 4,000 value, let's see,
868.64.
4,868.64. That's the total that was successful with the visa arbitration that we got back. The initial
5, Your Honor. 5.
Out of 5. Out of 5, but we never received anything for the.
He took 5 payments from me.
Okay, it's his turn now, Mr. Salim.
Sorry, I'm just trying to clarify, Your Honor.
Yeah, so we never received the 5th item that was there. And when we had an email exchange as well when we initially brought up these claims as well. And when we brought up the arbitration, I know Zoe sent an email asking us to pull back our arbitration claims that we made through Visa. And he gave us like a 5 business days to respond back, and we responded as well accordingly, with our concerns and the different things that we had issues with. That was under email 35. So we tried to also see if we can work something out, because even in the scenario where we weren't able to get all of our refund back, like there could have been some type of thing that could have been done where like if they really wanted to work with different individuals, that they would be willing to refund at least some, if not all of the expenses that were made, especially if it was several months out, and especially if it was something that we hadn't even started official event planning. Like we hadn't coordinated with their their caterer. They hadn't purchased any meal stuff. Like there was nothing that was purchased or that was, prepared in a sense, like for equipment and items for the venue to say that, these fees that they're holding, like is something that would, like that they've used for something. Like if it was something that like where it was specifically and like used, or if they really want to resolve this amicably, they would have been willing to work with the client during the cancellation.
Okay. All right, thank you. I'm just sorting out my thoughts here.
And we have like also like some, I don't know if I'm sorry.
I think I'm ready to make a decision. And but I don't want you to feel that you weren't fully heard. So if you want to make another comment, go ahead.
Yeah, and one of the things that we wanted to also say too, it's like, if like obviously for our what we're asking the court to do, or in terms of an order of preference, is like option A, like be able to provide the full refund for the 6 payments that we made because of the arguments that we made. And option B, we would forfeit the initial deposit, for like reserving the venue, but refund the 5 voluntary payments that were made. So in this case, 4 of which were refunded by Visa, and then 1 of which was, that we never received back. And then option C just allow us to keep the amount that was returned by Visa, and then we forfeit the remaining amount, for the initial deposit that was made to reserve the date, and with one of the retainers that was paid. And or like option D would be, we would retain, we would just owe back whatever the initial deposit was, plus the arbitration losses of 1,800 that so would be there. So from total, that would be like that 4,868.64 that we got back, and then like minus the amount that we would have to pay back. So it would be 582.84 that we would owe to the Empress Estate to cover for the initial deposit that was made plus the arbitration losses.
Okay.
Your Honor, allow me a couple of 1 minute or so.
All right, 1 minute. Go ahead.
Okay. So the way we do our business is we take the venue rental and the minimums, and we divide that to make it easy on the customers. Okay, so that's how you see those payments for 10 months. So it's a one retainer that we trying to make it easy on the customer, and a lot of color younger and stuff. So that's what you see. There's no initial deposit, and it's all one thing. It's just we split it. That. Another thing, Your Honor, I'd like to address is I also have 3 options, which I'd like to get the first option, which is I'd like to actually file another small call to get the rest of the money, because I like a lawyer fee, which is outside of whatever that we're doing right now. That's what arbitration. I have a clause in the contract that does say that. Particularly, so that clause in arbitration that should be, they should have gone through that same exact local. But the arbitration that they took, it's almost like a lawyer fee that has to be outside. But if you would allow me to do the first option, where I can file another small court, that would be great. If not, then option B is $5,000 plus the 1,800 for the arbitration fees. It's all up to you, Your Honor, but I'd appreciate getting the actual cost, which is a very minimum. I have to repeat that whatever things I may get, it's very minimal from the amount I actually could have done if I had continued.
All right. I think I know where I'm going with this. So Thank you, everyone. And I appreciate you taking advantage of the small claims process. You both are saving a lot in attorney fees that this case could lead to. And so I appreciate you taking advantage of that.
Thank you.
Let me make some general statements. First of all, I don't think this court is bound by anything that the Visa Dispute Resolution Tribunal did. I think the rules are different, and I don't think I'm bound by what they decided. So that's the first thing. Second, my experience in my practice and the review of Washington law is that Washington enforces contracts. You might have some states which are a little more forgiving, I guess. Washington isn't very forgiving. Washington says if you signed a contract, we're going to assume you read it, we're going to assume you understood it. So that's kind of, I guess, a beginning point is I have to look at the cancellation policy, which says if the client cancels the event, all retainers paid up to the point of cancellation will be forfeited as liquidated damages with no exceptions. The Empress Estate recommends purchasing wedding cancellation insurance to protect against unforeseen circumstances. Liquidated damages is what that means is the Empress is saying these damages are hard to calculate. We've reserved June 12th, 2026 on our schedule. And if you cancel at some point, there's no guarantee we're going to be able to fill that slot. Whereas if you never reserved that slot, then maybe back in April or May, we would have found somebody else to fill it. But we don't know what those damages are. We don't know how much that party would have paid. We don't know how much catering they would have bought from us. And when damages are unknown like that, then you have what's called liquidated damages, or you can ask for it. What is also clear here is the Empress is not coming to the defendants and saying, pay us the rest of the deposit, because they owed more at the time they canceled. But the Empress policy was, we're going to keep what you paid us, and we're not going to go after you for any additional. I do not view the deposits as voluntary. That was a payment plan that was set out in the documentation, that it would be paid over a certain number of months, not to exceed 10, but it was a payment plan nonetheless. So I don't see those as voluntary. Now I want to look at more specific items. So I'm looking at a September 2025 email from Audrey. And the testimony is that the defendants talked to the Empress, including Mr. Salim, in April about having an outside caterer come in. And there seemed to be no issues, or there was some accommodation. This email, though, says, wanted to follow up per our phone conversation. Happy and excited to hear that you are willing to work with us. And with the caterer option, we were interested since we were looking for a halal Indian cuisine. We have been working with a caterer and have found the perfect one to bring that concept to life. I'm going to find by a preponderance of the evidence, this was the first time the outside caterer came up. Just the tone of that email, happy and excited. It doesn't say, as we discussed in April, we have located an outside caterer. It says, per our phone conversation, which sounds very recent. So that came up in September. And I'm going to acknowledge that Mr. Salim was very accommodating. So on September 20th, same day, let me just check the times here. So this first email was at 11:59 a.m. He responds at 5:40 p.m. It was a pleasure discussing how we can accommodate your vision of incorporating catered food from adult cuisine of India into your wedding day at the Empress Estates. We're looking forward to working with you and your chosen caterer to bring your dream to life. Below you find a detailed response, and it says, we are excited to work with the adult cuisine of India. That certainly would lead anyone in the defendant's position to say, this is going to work out. And there's nothing in here, I'll acknowledge, nothing about additional cost. Then apparently they get Exhibit A3, which lays out an $8,000 additional cost for the caterer. And then on September 23rd, there's an email. After our recent phone discussion on Friday and our review of the recent banquet event order, which was dated September 20th, we are surprised to see the amount of additional service charges. These additional service charges were not disclosed to us during our tour visit cost discussions and signing for our reservation of the Empress Estate in April, even though expressly we were looking to use outside catering. I mean, we said that. During that time, we originally expressed our interest and intent in wanting to use an outside caterer. So, but neither in the email nor it sounds like in this preliminary discussion was that discussed. And then the email comes back from Mr. Salim. Thank you for sharing your concerns. We have reviewed your request to use an outside caterer. Catering is core part of our all-inclusive package, and outside caterers are not permitted. Our standard package is to incorporate 1 to 2 cultural dishes, and it goes on, really changing the tone. I want to acknowledge all of that. Because on an emotional level, the defendants certainly have a right to feel that this went sideways, that they thought they can bring an outside caterer. There was nothing discussed about cost, and then all of a sudden they're given a great deal more cost, and they end up canceling. And they certainly had the right to cancel, I think, under these circumstances. The question today, though, is what do I do with these 2 claims given the contract that we've got? And I don't think I have any other choice here but to find in favor of the Empress. and award them the amount that they're asking for, which includes the payments that Visa decided to return, but I find were liquidated damages under the contract signed by the defendants. And I want to say that completely understanding the defendant's surprise and position, but I don't think there's a legal basis that I can change that outcome given the contract that we're dealing with. Okay. Now, Mr. Salim thinks there were additional damages and he wants to file a small claim, another small claims case. I'm not making any decision on that. I'm not agreeing to that. I'm not disagreeing to it. If he wants to do it, he can, but I'm not saying whether that's going to be an effective or valid claim. But I am going to find in favor of Mr. Salim and the Empress in the amount of $4,868.64.
Audrey and Amjad just wanted their culture to shine, but Zoe's hidden fees cross